Hello and welcome to yet another episode of the new series. This is going to be one of our most important segments. I am going to take you through the Kesavananda Bharti landmark judgment, which took place 50 years ago. We are celebrating or observing the 50th anniversary of this case today, that is on April 24th. My name is Pooja Trivedi. It is important that we understand this topic from the perspective of GS Mains Paper Second and of course the preliminary impacts as well. So let us see what do we have to cover. First, let's talk about the news. Now, the 50th anniversary of Kesavananda Bharti case is being observed today. Here, we are talking about the case which was specifically named Kesavananda Bharati Sri Pada Galvaru and others versus the state of Kerala and another. Here only, the constitutional bench of the Supreme Court laid down the basic structure doctrine which evolved throughout many years. We will talk about that as well. Moving ahead, now if we have to talk about Kesavananda Bharti, he was born in 1940. As Kesavananda Bharti took sannyas at the age of just 19 years of age, he headed the Edinate Mutt, a Hindu monastery in Kasaragod, Kerala. In 1961, still only 21, he was appointed as the head of the Mutt, a position he held till his death in 2020. He passed away in 2020. A proponent of the Smarthas tradition of Advaita Vedanta at the Mutt, Srimad, his honorific title, as he was the head, his honorific title was Srimad Jagatguru Sri Sri Sankaracharya Thotakacharya Kesavananda Bharati Sri Padangalavuru. Okay, so this was his title. As you can see, I have also attached one picture. The Edinate Mutt, it is believed to have been established by Thotakacharya. He was one of the 4 original disciples of Adi Shankaracharya who synthesized the non-dualistic philosophy of Advaita Vedanta. Kesavananda Bharati was known to be a patron of Hindustani and Carnatic music as well as Yakshagana, which is the folk theatre. It's a folk theatre, remember that. And this folk theatre belongs to certain districts of Karnataka and the border districts of Kasaragod, Kerala. Moving on. Now, his relation to this particular basic structure doctrine, let's establish that. His constitutional aims wasn't such that he is going to, take out his entire life throughout a case or something like he is going to establish constitutionally important cases. It wasn't like that. He was just fighting against the Kerala government's Land Reform Act, which also impacted his Mutt. So he was challenging the 1969 land reforms, which was enacted by the communist C. Achyuta Menon government. And under this reform only, the Edinate Mutt lost a large chunk of its property to which it owed its financial woes. He filed a writ petition in the Supreme Court, and of course, his lawyer was Nani Palkhiwala. So through his lawyer, he established that this Land Reform Act was in contravention or violation to the fundamental right to religion, Article 25, freedom of religious denomination under Article 26, and back then the right to property under Article 31. So these were the major fundamental rights. He said that it was challenged by these Land Reform Acts. So 4 cases which are very important for us to know from the perspective of basic structure is Shankari Prasad case of 1951, Golak Nath case of 1967, Kesavananda Bharti case of 1973, and Minerva Mills case of 1980. We will also talk about the basic structure. So Shankari Prasad case, in here the Supreme Court was of the opinion that the power of the Parliament to amend the constitution under Article 368 also includes the power to amend fundamental rights. So it established the Parliament to be the supreme authority in the country when it comes to rights and laws. Here it had the logic, the Supreme Court had the logic that the word law mentioned in Article 13, it includes only ordinary laws and not constitutional amendment acts. Remember that. Now the second is Golak Nath case of 1967. Here the SC overruled its judgment, in which case in the Shankari Prasad case of 1951, it ruled in this that fundamental rights are given transcendental and immutable position. Hence, because of this, the Parliament cannot abridge or take any of these rights. So as you can see, these two cases produced very extreme position of the Supreme Court with respect to the Parliament's authority. One said that okay, Parliament is supreme, it can amend even the fundamental rights, abridge even the fundamental rights. Whereas in the Golaknath case, it said that no, it cannot be abridged or taken. So Constitution Amendment Act is also a law under Article 13. This was also stated by the Supreme Court. Now Parliament reacted to this particular judgment of Golaknath case and said that we are going to enact 24th Amendment Act, in which a provision is provided in Article 368, which declared that the Parliament has the power to take away any of the fundamental rights. So Parliament was reactionary. Then Kesavananda Bharati case came, and we will talk about it in detail, but just the gist of it is going like, SC overruled its judgment in the Golaknath case. Here, it upheld the validity of the 24th Amendment Act, but also opined that the Parliament is empowered to take away or abridge any of the fundamental rights. But the Parliament has to keep in mind the basic structure of the Constitution. So basic structure doctrine was evolving indirectly, but very clear cut it was laid down by the court, the apex court, in the Kesavananda Bharati case. We'll talk about that in detail. In Minerva Mills case, what happens? That the Parliament reacted to the above case by enacting the 42nd Amendment Act, and it declared that under Article 368, there is no limitation on the constituent power of the Parliament. Again, Parliament says, I am supreme here. So you can say that there is a tussle that is going on. There was a tussle that was going on between the executive and the judiciary when it comes to who is the final lawmaker in the land that is India. It barred the courts from questioning such amendments. Now, the provision was invalidated by the Supreme Court, saying that the Parliament cannot take away the judicial review power of the Constitution, since it is a part of the basic structure of the doctrine, as it is trying to say that we are the final interpreter of the Constitution. We have a duty to uphold the Constitution, so you cannot be the boss over here. Moving on. Now, the outcome of the Kesavananda Bharati case was such that the Constitutional Bench in this particular case was ruled by a 7-6 verdict. It was divided, and the Supreme Court opined that the Parliament could amend any part of the Constitution so long as it didn't alter the basic structure of the Constitution, which the forefathers had in their minds when they were drafting the Constitution. The court didn't define the term basic structure. On this premise only many criticisms have occurred, and the court said that only a few principles such as federalism, secularism and democracy, these are the certain basic structures. These are very open-ended terms, and because of that, lot of criticism has been, there were a lot of critics. There are still a lot of critics with respect to the ambiguity of basic structure. So it is nowhere written that these are the basic structure of the Constitution. It's not given anywhere. But throughout the evolution of different cases, we can say that the supremacy of the Constitution, rule of law, independence of the judiciary, doctrine of separation of powers, sovereign democratic republic, parliamentary system of the government, principle of free and fair election, welfare state, etc. These all comprise, or these all are a part of the basic structure. An example of application of the basic structure can be seen in the S.R. Bommai case of 1994. Here the apex court upheld the dismissal of the BJP government by the president following the demolition of the Babri Masjid, invoking a threat to secularism by the government. So secularism or secular nature of the country is a part of the basic structure. It is, a manifestation of the basic structure. So significance of the basic structure is such that it is providing a testimony to the theory of constitutionalism. See, there is no autocracy or dictatorship in this country. There is one supreme law, that is the Constitution. And the basic doctrine has saved Indian democracy, giving the rights, the power to the individuals to exercise their rights properly. It helps us to retain the basic tenets of the Constitution, which were, given to us by our forefathers. It strengthens our democracy by delineating true separation of power. That although legislators are there, executors are there for implementing the policies, and judiciary is there to finally, have a say in what is correct or what is not. So this is separation of power. It provides the basic rights to citizens, that fundamental rights, although can be abridged, but basic structure should not be, struck at. Now, there is a common criticism about this entire thing, is that the doctrine has no basis in the Constitution's language. There is nowhere written that you have to preserve the basic structure. What is this? All along the Supreme Court has been saying what the basic structure should be preserved, but what is the basic structure? We do not know. Judiciary has a power to impose its philosophy, because it has time and again told the legislators and the executive that I am going to finally interpret the Constitution. So it is also given an outlook that the judiciary is the supreme body in the country, also in the entire world. There is no definite elucidation on what exactly constitutes the basic structure. So these are the certain criticisms. So I hope you understood this topic. That's it. Thank you so much for watching.